I listed the title about discussing about the legality of Project Melee, and also I'll be streaming Melee later today. But it's just been it's been a while. It's been a long time since the Project Melee community really started up and became really popularized, and there's a deep what's it called, competitive scene, and I'm not sure exactly how the competitive scene is doing nowadays, but there's still this. Of course, I had my own opinion about the legality of Project Melee since I came out. Ever since I've been handling some copyright lawsuits for other types of cases such as fabric goods and even for karaoke music. Believe it or not, I actually handled a few of those cases. So now I have a better understanding of how copyright lawsuits work, and also it's been a and also as I said before, people have been really. I expected people by now to have a much better idea of how of how copyrightable of how the copyright field works, but it looks like people are still very confused about it, and people are still playing Project Melee to this day. And essentially, and in my opinion, essentially just playing it without any regard to how legal Project Melee is, and it's almost, I don't want to say this, but I think this example explains it perfectly, where it's pretty much playing Project Melee while having your head dug being buried under sand, and it really is that way, to tell the truth. And it's just my own personal opinion. Nothing that I will say constitutes legal advice. I am not your attorney. I am not anybody's attorney when I'm talking to this. I do not want there to be any confusion as to whether I was your attorney when I'm generally speaking about copyright cases, and also talking about the legality of Project Melee. I am not your attorney. I cannot emphasize this enough. Do not when people ask you, when people like, if the worst case scenario happens and someone asks you, how come you made this business decision, you cannot just say, oh, it's because Bizzarro Flame told me to. Bizzarro told me that this and this is legal, and this and this is not illegal. I do not do that. What's it called? I am only doing this just as a guidance for people, and just for people not to and for people to have a better idea of what copyright is and how it applies to Project Melee in an overall scheme of things. And what's it called? Wilcher Dude, how's it going? What's it called? We have Zoe here, MBK underscore SSB, and we have Hubert Neutron here. Thank you very much, guys, for tuning in. Of course, we have a previous people. We had a, let's see. We also had it was a Hyperflame was the inside here. Thank you very much, Hyperflame, for tuning in. And Yink, what's it called? It makes me smile. I'm just gonna read what MBK says really quick. It makes me smile with things like this. The guy who screamed easy money can be super hyper while playing Melee is just really calmly talking about legal stuff. Appreciate it, man. And Lord Genome, what's going on? But yeah, so I'm just going to do, first of all, I'm just going to do a very brief overview of what copyright law is, pretty much. So copyright law is a protection of not ideas, but their protection of expression of ideas. So let's just say, you thought in your mind, oh look, I'm going to make this one. Let's see, let's think of an artistic expression. I'm going to make a drawing of a totally fictional alien species. Okay, but then I'm not going to draw it. I'm just going to think about it. I'm going to tell people about my ideas about of what the features would look like. That is not copyrightable in and of itself. That is only just an idea. A copyright has to be an expression of the idea, such as drawing this brand new alien species that you just imagined in your head, and pretty much selling it for a profit, that is copyrightable because it was an expression. It was actually executed. Same thing for computer codes. Computer codes are strictly protected under copyright law. And BK, you remember my name? Hey, what's it called? I would hate myself if I forgot your name, Zoe. Especially after only one day, man. Does PM count as fair use? I will get to that. So, as to my opinion, so just hold on a second. I'm just giving you a brief lesson as to what copyright law is, so that people don't ask repetitive questions later on when I talk about Project Melee. So, let me make this easier, guys. And there's this one good website that pretty much lays out what copyright, what elements you have to prove in order to prove that a work is copyrightable, and whether that was an infringement of the copyright. Like, infringement would be an equivalent of let's say for a car accident, like if you're negligent, failing to brake at a reasonable amount of time before crashing into the car in front of you. That's pretty much like the same analogy used for infringement. Did your work infringe upon a copyrightable idea that's copyrighted by that is protected by copyright law? So let me just pull up this this very helpful article that briefly explains what the elements of a copyrightable work is, and also the element of what constitutes copyright infringement. Let's see, let's go to browser. I guess I'll scroll in some more. Let's see. I'm pulling up this article from the American Bar Association website, and this is very helpful. Let me just check who wrote this. Jason E. Sloan. He is an associate attorney at Paul Weiss Rifkind and the Wharton and Garrison LLP's New York office. Thank you. What's it called? I have to give him credit for writing this article, because I always want to give credit to everyone to whom I refer, to whom I use an article for explanation. Of course, this explanation to you guys is of course protected under fair use, because I am using this website article as for educational purposes, not for profit purposes or so on, or something like that. I just want to put out that disclaimer first. Right now, what you see on this website is just an introduction. But let's get right into the elements. So let's read this right here. I know the language already, but I just want you guys to have to just be able to look at it, to be able to read it, so that it's as clear as possible. So let me see if I can capture cursor also. Do I have anything that can capture cursor so that I can read? Let's see. Just trying to see if it can capture my mouse. Let's see. Okay, so I guess I can just highlight it and it'll show. Okay, so an action for copyright infringement may arise where a third party violates one or more of the exclusive rights granted to copyright owners. To establish infringement, the plaintiff must prove, number one, ownership of a valid copyright, and number two, copying of constituent elements of the work that are original. I'm going to talk about ownership very quickly, because of course Nintendo has sole and exclusive copyright of Super Smash Bros. Melee, the original work that they completely created, and of course all the ancillary copyright licenses obtained by Nintendo to maybe rights that are not originally Nintendo's rights, but maybe could be borrowed from another third-party company. But but the point is that I'm pretty sure there's no contest as to whether Nintendo owns Super Smash Bros. Melee or not through its subsidiary HAL, HAL. I'm sorry, I don't remember the full name of HAL, but I'm pretty sure it should be like HAL Inc. or something like that. But I'm just going to breeze through the ownership portion really quickly. So, but before I begin, two main. So let's say that we have a lawsuit. We have a lawsuit that is that's like an umbrella of everything. So lawsuit, and a copyright lawsuit, and then in order to prove copyright, you need to prove two things, two big elements. One is ownership, other one is copying. So we're going into the element number one, ownership of a valid copyright. So let's see. So ownership. Let me just make sure that it is highlighted. Ownership of a valid copyright consists of originality in the author, copyrightability of the subject matter, a national point of attachment of the work, such as to permit a claim of copyright. Number 4, compliance with applicable statutory formalities. And 5, a transfer of rights or other relationships between the author and the plaintiffs as so as to constitute the plaintiff as a valid copyright claimant. And of course, a copyright registration certificate from the Copyright Office serves as prima facie evidence of elements 1 through 4. If the defendant rebuts the plaintiff's prima facie evidence, then the above elements of valid copyright ownership become essential to the plaintiff's case. And of course, it says right here, the primary discussion in most copyright infringement cases, and here is the second element of infringement. Basically, like I mentioned before, ownership, and number 2 is copying of constituent elements of the work that are of the original. So and that pretty much goes back to what I'm saying, in that number one big element, ownership, is usually never contested in a lawsuit because most of the lawsuits you have people who you have a company or a person who already can prove without a doubt that they're the creator of the original work that is at issue. But let me just breeze through ownership really quickly. So we have number 1, originality in the author. Of course, this was created by by Nintendo. Super Smash Bros. Melee was created by Nintendo. I don't have to go deep into that. Copyrightable of the subject matter. Of course, it is copyrighted because it is a video game, and video games are really composed of mainly codes. And like as I explained before, codes are strictly protected by copyright law under United States codes, and it is codified as clear as day in order to prevent any ambiguity or any confusion. Number 3, we have a national point of attachment of the work, such as a permit to claim of copyright. So I mean, what's it called? This isn't even an issue because it's already as I explained earlier, it is a Nintendo sole product. Compliance with applicable statutory formalities. This is never an issue. And I am not going to go into much explanation why. And 5, a transfer of rights or other relationship between the author and the plaintiff so as to constitute the plaintiff as the valid copyright claimant. As I said, Nintendo is the original author of Super Smash Bros. Melee, so it is obviously obviously met. And of course, as I assume that a copyright registration certificate it was already obtained by Nintendo, because they do that. They usually retrieve copyright registration for every country to protect its own intellectual property, such as especially their own games, their own first-party games, such as Super Smash Bros. Melee. So and what a copyright registration certificate does is that when you apply, your work is naturally protected under copyright law. Like, even if you don't have a certificate or registration certificate, it is still copyrightable. but then getting a copyright registration certificate from a copyright office expands your copyright across the United States. It's not, because without a certificate, it is limited in protection within a particular region, and of course and also another benefit of receiving a copyright registration certificate from a copyright office is that it already rebuts plaintiff's prima facie evidence, and which means that it is even easier to prove that you are the owner, or a corporation is the owner of the valid copyright. It automatically makes that presumption. Of course, the defendant, the one who is getting sued, can still challenge that, but it's going to be that much of a higher hurdle for the defendant to challenge that. Now, in my opinion, it is clear as day that Nintendo has ownership of a valid copyright, aka Super Smash Bros. Melee, and of course the other Super Smash Bros. Game within the relevant franchise. This is Super Smash Bros. Franchise. But then the more important element that is usually the main issue would be the copying of the constituent elements of the work that are original. Or in short, was it substantially copied? Was the original work substantially copied? Now, I'm going to so element number 2, I just mentioned it, is going to have another branch. So far we have on the top copyright lawsuit, 2 big elements: ownership, and then we have a substantial copying. Now with the substantial copying element, there's going to have mini elements. So we're going to have mini element number 1. Let me read this. Mini element number 1 includes proof of actual copying of the plaintiff's work by the defendant. And number 2, that such copying constitutes an improper appropriation of the plaintiff's work. And let me just scroll down a little bit. Now let's just read this together, just to make things clear. Copying involves a factual question of whether the defendant actually used the plaintiff's work in order to create his or her own work. It can be proven through direct evidence such as witness testimony, the defendant's own admission, such as an admission, just like, for example, like maybe the creator of PM said, "Oh, Super Smash Bros. Melee is what's it called? Saying something like, oh, we basically copied the entire Super Smash Bros. Melee game and just altered the physics code of Super Smash Brothers of Brawl." Okay, let's just say that. Okay, so let's just say the Super Smash Brothers Brawl, and we just we copied the entire game, or most of the game, but then we made changes to the code itself, like that could be an admission in and of itself. Maybe they admitted it on Smashboards or something like that, but it's just an example. Okay, or it can be proven also by photos or video catching the defendant in the act. Maybe like a Project Melee development video. Who knows? So more commonly, however, copying is demonstrated through circumstantial evidence establishing access to the plaintiff's work and probative similarities between the works. From this evidence, it can be inferred that, given the defendant's opportunity to copy the plaintiff's work by having access to it, and given certain similarities between the works, it is more likely than not that the defendant copied the plaintiff's work. So it's kind of interesting. So that's the first mini element of whether. Let me just go back to the mini element. Was there actual copying of the plaintiff's work by the defendant, and that's mini element number 1, and mini element number 2, that such copying constitutes an improper appropriation of the plaintiff's work. The confusing thing, from what I've learned so far, is that mini element number 2 can also prove mini element number 1 by showing that they're so similar that there is no other explanation. There is no other explanation than the explanation that look, these two works are so similar that the person who created B must have copied the work of person A or corporate or company or the company. So that in and of itself is proves that there was actual copying by the defendant of the plaintiff's work. Maybe I'll just take a mini break right here. I didn't really get to see your guys' comments so far. Let's see. Hey, what's up, AutoZone? So, what's it called? I have failed the city. I've been MIA from the Smash scene for a while. What's going on with PM? Are people being sued? I don't think I've heard of anyone being sued yet. But I'm just telling you guys what could happen, or whether if Nintendo decides to proceed with legal action, if they will be successful. So that's basically so I'm just basically giving my opinion as to what's going on. And like I said before, as a disclaimer, everyone, I am not your attorney. This is not legal advice. I am only giving my general opinion. I cannot give legal advice because you are not my clients. I am not your attorney. You are not my client. You cannot rely on my words to if you're actually trying to defend the defend yourself against a lawsuit by any entity or any person for copyright infringement or for any other lawsuit whatsoever. So, and True Melon is saying, pretty sure the PM development team have split up, RIP in peace, if they're getting hurt now. Yeah, so basically, the reason why I'm doing this right now is, or why I'm explaining this right now, is because I didn't want to really go into my opinion as to the legality of Project Melee until to let people figure it out on their own, such as maybe hire an attorney just to explain to them what their legal rights are, and if Project Melee, if a product such as Project Melee is infringing upon a company's work, such as Nintendo's or something like that. So I just want to wait to see, wait for people to come to understand what their rights are, or how the legal landscape looks for Project Melee, and it doesn't look like the community has improved their understanding whatsoever, from what I've been seeing, and people are still, and the thing is that I do not like to see people being scared, or I do not like to see professionals who actually play Project Melee to be scared. Scared without knowing what they're dealing with. So that's why I am streaming what my thoughts are on Project Melee's legality. And like I said before, I'm not giving any legal advice whatsoever. Although I do have some experience in this field, but I do not. But then you guys cannot use whatever I say as an excuse. Such as, oh, but Bizzarro Flame said this. I thought this was okay. No, you're not allowed to say that. I'm being very serious right now because it can affect me in the future if you guys claim that you guys relied on my words or relied on the stream to make business choices of your own. Now I just want to clear that up again. I cannot emphasize this enough, and I'll keep repeating this throughout my stream just in case if someone just tuned in. Okay, so let's go back to mini element number 2, basically copying. All right. So let's just go through this. let's just go through this this paragraph for mini element number 1. Access can be proven through evidence that the defendant had a reasonable opportunity to observe plaintiff's work. Such proof may consist of showing a particular chain of events through which the defendant may have gained access, or establishing that the plaintiff's work has been widely disseminated. Evidence that the defendant actually observed the plaintiff's work is not necessary. Such a broad inference of access due to a work's fame and wide dissemination can be made in part because infringement is a strict liability offense. The defendant can still be an infringer even if he or she unintentionally copied the plaintiff's work. This is true even if the defendant was only subconsciously aware of the work after unknowingly observing it years prior to creating the allegedly infringing work. Well, well, I mean, I think it's after reading this, it speaks for itself that this mini element can be proven by the plaintiff, such as maybe from Nintendo, I don't know, whatever, from Nintendo if they decide to bring a suit. It can be easily proven. I mean it's someone will be subpoenaed, or even as a defendant be forced to be on the stand and describe how Project Melee was developed. And of course that person will have to testify, well, we just ripped the codes off the main work, or I'm not a computer science major, so I cannot explain exactly how they derive the code from, but I'm pretty sure that it is a very easy element to meet in the court of law, because developer will have to testify that the codes were was derived or was copied substantially or exactly from Nintendo's work itself, Brawl, and of course they had to input their own codes in order to make the not copy, but in order to make the engine physics as close to Melee as possible, including so that advanced techniques in Melee can be replicated, such as wave dashing, L canceling, and other advanced techniques, and also to make it feel more like Melee. Now that's already a big enough. That alone is already very easy enough to prove that there was copying involved, or that there was that they had access to plaintiff's work, because they had to have used the Brawl's engine, or the entire Brawl code source in order to create Project Melee. Now that in my opinion, that's pretty obvious. You guys might think otherwise, but I think a normal reasonable person would come to the same conclusion as I just did. And for mini element number 1, it even supports the plaintiff further because of this following paragraph right here, where I'm highlighting. To complicate things further, courts have held that when two works are so strikingly similar as to preclude any reasonable possibility that the defendant's work was independently created, access may be presumed. Presumed meaning it may be assumed. You may automatically come to that conclusion because the two works are so strikingly similar. Now, to be strikingly similar, the similarities must be such that they can only be explained through copying, as opposed to independent creation. Come on, I mean, I think a reasonable person would automatically come to the conclusion that Project Melee and Super Smash Bros. Brawl and Melee, both games, are so strikingly similar that the only possible reason for the developers of Project Melee to get access to the codes is because they probably ripped it off from the original product itself, Brawl and or melee, as opposed to independent creation. So this is this means that mini element number one is very easily met. Is like I said, as clear as daylight. Okay, so there we go for mini element number one. Now, the most contested legal issue would be mini element number two, the probative. Let me highlight this right here: the probative similarities between the works. Now, here's the paragraph explaining about probative similarities. In addition to access, it must be proven that the plaintiff's and defendant's works share certain probative similarities that collectively help to prove that factual copying has occurred. Proving such similarities serves to negate any claims by the defendant that he or she independently created this allegedly infringing work free from the influence of the plaintiff's work. Unlike substantial similarities, which are at the heart of the improper appropriation inquiry, probative similarities may be found to exist even in the unoriginal and non-copyrightable components of the plaintiff's work. The type of similarity that is generally regarded as the most probative of copying is the existence of common errors, whether factual or aesthetic in nature, between the two works. The plaintiff can attempt to prove that the likelihood of such errors occurring independently is too great to be merely a coincidence. So, okay. So let me start this off for mini element number two, probative similarities. So we have so many different types of qualities of the original work in Super Smash Bros. Brawl and Super Smash Bros. Melee. So we have Brawl. So we have so many different copyrightable aspects of Super Smash Bros. Brawl and Melee. You have the story. You have each and every character that are copyrightable in and of itself. Yoshi by itself, copyrightable. Ganondorf by itself, copyrightable. So basically, and also number three, we have music. We have how many music tracks? Hundreds of different music tracks that Project Melee would be infringing upon. Hundreds. And then we have stages. Even stages would be copyrightable elements because of the design of it is copyrightable. And we have the menu option. Menu option is copyrightable also because it's almost exactly the same if I remember correctly. Number 6, we have trophies. Trophies are copyrightable because they are unique. They are ideas that were executed by HAL. And also remember, trophies can also include if you remember, Brawl had trophies from other games that are not part of Nintendo. So the thing is that if there's access to trophies in Project Melee, then they could be subject to copyright lawsuit, not only from Nintendo but from other third party companies such as Konami, because you have Snake in there. Oh yeah, and Snake as a character is copyrightable because Nintendo obtained the license to using Solid Snake only for the work of Super Smash Bros. Brawl. And do we have any other third parties? I can't think of any other Brawl third party character. Let's see. Yeah, there are others. And you have trophies. You even have Xenoblade Chronicles, I believe, and that can be a I think the producer of Xenoblade Chronicles would be Monolith Corporation or something like that, if I remember correctly. I love Xenoblade Chronicles, by the way. Amazing game, one of the best games for the Wii for sure. But that company has a right to sue the Project Melee for infringing its rights, so that's possible. And of course, and don't forget the music from Xenoblade Chronicles, the music from Metal Gear Solid. Those are also copyrightable. Those are also copyrightable, and then you have others. And I think Project Melee also has single player modes, which are in and of itself copyrightable. Also, the modes by themselves are copyrightable. So, and let me think of others. And even the mini games inside Super Smash Bros. Brawl are copyrightable because it's exactly the same. The stage builders also copyrightable. So in my opinion, you have thousands of copyrightable of individual copyrightable let's see single copyrightable products or should I say works? Sorry, I just I was a little bit kind of lost my train of thought there. But you have copyrightable works, thousands and thousands of them that are being infringed, that could be potentially infringed upon, and probably are infringed upon by the developers themselves. So it is so you have and not only by Nintendo. They can also be sued by the original authors, such as Monolith Soft Corporations or Konami or any other third parties that are that granted Nintendo the license to use them for trophies or for music or for even other copyrightable works. It's really scary, guys. There's just so much like there can be like it's almost like it is playing with fire in a way, if but then I'm still not completely done with the discussion about Project Melee. I'm just giving you guys like the major bad news first. So you have those elements. So mini element number 2. As let me just repeat this one more time for you guys. It must be proven that the plaintiffs and defendants' work share certain probative similarities that collectively help to prove that factual copying has occurred. Well, of course, everything in Project Melee is it appears to be. I mean, it appears to be copying exactly the same character models, the same stages, the same music. The same music is there, and I've even heard that that in Project Melee there's some music that's taken not from Brawl or Melee of itself, but also from other musicians and artists without their permission, without their explicit permission. So all in all, you have all these elements being met to prove copyright infringement. Of course, there are special affirmative defenses that can be used as pure defenses, so that even if the plaintiff, aka Nintendo or any other company, shows shows without a doubt that there is copyright infringement that took place, then they can still. There's still affirmative defenses that can wipe all that out and wipe the entire lawsuit out by the time trial comes about, and just protect the project purely and it would just be a miracle for Project Melee if the worst comes to worst and there are lawsuits flying all over the place. Let's see. I'm just going to take a little break right now before I get into the affirmative defenses. So hang on, guys. What's up, SB Murloc? Oh yeah, we have Sonic also. Don't forget about Sonic. So that one is. Let me look up the creators of Sonic. Do you guys know who created Sonic? I am brain farting right now. I just is this is it third party or is it? I guess it's strict. Is Sega the first party creator of Sonic? Yeah, something like that. Yes, Sega. Okay, and Sega didn't get license from another company to use Sonic, right? It's Sonic's own creation. Okay, just making sure. Yes, Sega can also get into this lawsuit if hotbed of lawsuits if they want to. Let's see. Let's see. I'm just going to read previous comments. There's a lot of comments right now. Can you get in trouble for simply playing PM or just developing it? I guess, can you ask me that question after I'm done fully discussing Project Melee? Because I need to get the basics out of the way. Let's see. Good analysis as always. Oh, thank you very much, NK42 Cloud. I don't have a script in front of me. I didn't prepare for any script, but I'm just going off. I'm just doing it on a whim, pretty much, just because, like I said, I'm not providing legal advice. I did not conduct any legal research, but then I do have an understanding of copyright law from the previous lawsuits that I handled, especially on the defense side. So that I can give my own opinion as to the legality of Project Melee. And then Zoe's aka MBK_SB says, sorry, arguing with the moon on Twitter, be back a bit. That's funny. Let's see. Top player privilege is too strong. Tired of arguing with the moon. Alright, I'm not gonna inquire about that. It's a hack. I consider it like Rivals of Aether, but a lot like 4XM Smash 4 hack. I'm not familiar with what he's referring to, what he's exactly referring to. AK Paradox says, I have failed the city, saying there's no way you can get in trouble for it if you have it, but streaming it or making it public or known, probably for sure. I'll get back to that subject after going through the basics. Pryface, the moon is. I'm not gonna finish that sentence. I'm not going to throw any. I'm not going to talk about any qualities of a smasher, even if it's comment by another person, not for myself. Okay, RR versus DE pools. Sonic, every character, lol. Yeah, every character. Even Wii Fit Trainer. I'm pretty sure that was developed. I'm pretty sure that was Nintendo was the first party developer of a Wii Fit Trainer and Wii Fit Gaming. So if the PM development is no longer together, would Nintendo still be able to sue them if they decide to go through with the copyright? They can. They can sue anyone. They can sue the professional players if they want to. They can sue. They can sue whoever they want. Actually, that's a good question. Because can you sue anyone that you want in a lawsuit, either state or federal court? Yes, you can. For example, I can sue. What's a stupid crazy example? I can sue my neighbor for getting me sick, for coughing from the confines of his own home and spreading that germs, and I can say he spread that germs to me, and that because of him I got sick and I had to incur hospital bills. I can sue for that, or I can sue the president Donald Trump for being physically offensive to my eyes on television. So basically, my point is that you can sue anyone for anything, and that's the scary part about it, because in America, you have the right to sue anyone for anything, even if it's completely false. But of course there could be ramifications. There can be negative side effects of suing someone under a frivolous lawsuit. You can sue anyone for anything. Let's see. I can sue Plup for playing golf, and for not telling me about it. and I can just put that in the lawsuit, file it, and serve him, and have a attorney service serve him, and then he will have to respond to the lawsuit or get a judgment against him. Basically, people can sue anything for anyone. Yeah, I could technically sue Kage for backing out this Apex 2015 Salty Suite, but then it'll be a frivolous lawsuit because there's no legal basis for it. So I'm just giving crazy excuse, but I just want you guys to know that you can sue anyone for anything, really. But of course, it's gonna cost money for you too, and usually lawsuits, most of the time lawsuits are not worth it unless if it's more than like $10,000 in value, or even then, like corporate companies prefer to shy away from lawsuits that are not at least like 100,000 or 50,000. You know, it's just because you have to pay the attorneys, or either that or attorney takes a big cut of your recovery. The beef continues. It's hilarious. Anyway, thanks so much, guys, for tuning in. So I'm still not done with my analysis of Project Finale. So my overall summary is that for proving copyright infringement, it will be totally lopsided towards Nintendo's favor. Very easy to prove copyright infringement. However, like I said before, there are affirmative defenses that can absolve the defendant of all liabilities, as long as it can be proven, even if the plaintiff, aka Nintendo or any other third-party companies or first-party companies, prove that the PM developers or anyone else infringe upon their products. Okay, and like I said before, this is not legal advice. I am not your attorney, not anyone's attorney for this matter. Nothing. You should not take this as legal advice. I will not be responsible. I will not be responsible whatsoever if you guys use anything that I said to make your own business decisions or to make any decisions, and end up being sued by a company or something or anything like that. Also, one more thing before I continue: cease and desist letters. Everyone's so scared of them. It has no legal effect whatsoever. Cease and desist letters. The only reason why companies and people send them out against mostly their enemies is just to scare them. It's just to prove just to give them a heads up that they will bring a lawsuit. But it in and of itself does not is not a judgment whatsoever. It's just a warning. It's mainly just a warning or a scare tactic. But it can be used in the court of law to convince the jury or the judge that more damages, that there should be more monetary damages, or injunctive relief provided. It's pretty much you can use the letter by saying to the jury or the judge in your during trial that, look, this company or this person or whatever person infringed upon my work, I already gave them a cease and desist letter. They did not listen to me, so you should award me more money because I already warned them about it, and I said that I would bring up a lawsuit, and they still didn't listen. So you should punish them for not listening to us, and not by ceasing and desisting. Just want to clear that up, okay? Great. Glad we had that understanding. All right, so let us go into affirmative defenses. I'm not gonna list all the affirmative defenses because they're like tens or I think there are like more than 10 affirmative defenses that you can use, or maybe even more than 20. But most of them will probably not play a part in this. The main affirmative defense that I can think of is affirmative defense of fair use. In order to help myself, in order to help you guys, in order to understand more easily about the concept of fair use, just give me a second, and and I'll find another article by the AmericanBar.org. If not, then I'll use another website to help me demonstrate what fair use is. Be right back, guys. All right, I'm back, guys. That was quicker than expected. Let's see. Before I begin, I'm going to just read out the title of this article: "Fair Use in News and Reviews, Volume 28, Number 6, by Pierre Voudrag. Pierre Voudrag practices media and sports law in Southern California." Thank you very much, Mr. Voudrag, for this article, which will help my viewers, or this channel's viewers, to understand the concept of fair use. Thank you very much. And if you ever watch this video, then please feel free to discuss any matters that comes to your attention. Thank you very much. Anyways, I'm going to start off by reading: "Fair use is a doctrine that is used to encourage criticism and commentary of copyrighted works. It is based on the concept that one should be free to use portions of copyrighted materials without asking permission from the copyright owner. It is an equitable principle that is frequently used as a defense by those sued for copyright infringement." So basically, let me go into history for the fair use doctrine. Copyright law has been existent almost near the beginning of United States of America's history, because we need to protect works such as Benjamin Franklin's work, or Thomas Edison's work. We need to encourage people to start inventing pretty much useful inventions throughout everyday life, light bulbs, computers, and so many different copyrightable pieces of work. So that copyright was strictly codified under the United States Code in order to innovate creations, and it is very understandable that we have copyright laws that help protect authors of creative works. Of course, there are other types of intellectual property laws, such as trademark law, patent law. We even have trade secrets law, which is protected under both federal and state laws, state common laws. I should add, and even state statutory laws. But the doctrine of but in the early 1900s and or mid 1900s, people kept on getting whacked with lawsuits here and there, because especially news organizations who are just trying to report on news, but how can they show the viewers about what's going on when they keep on getting sued for using someone's piece of work, such as art or such as maps. So in order to protect certain organizations and certain people in particular fields from getting sued all over the place, or being sued to bankruptcy, they put forth additional codification and also case law concerning fair use, and they kept expanding upon this doctrine in order in order to carve out more and more protection for these particular groups, especially news sources or informational groups or reporters or independent reporters. For example, you have what's a good example? We have of course traditional news channels. They're usually protected by fair use. We have another good example would be informational channels on YouTube. They're protected because they're just using copyrighted works that are otherwise protected by copyright law to explain what is going on in the world, or to explain or to provide educational education to the general public, such as including the general viewers who view their YouTube content, and of course that is what fair use doctrine is meant to protect. A good reason for this protection is that copyright law it does two things, to tell the truth. It protects creativity, but at the same time it restricts creativity, because how are you supposed to further creativity if you cannot use other people's creative works to expand upon their creativity? So that's what the fair use doctrine is used for. But of course, the fair use doctrine or defense can only go so far. So that's just a basic background of what fair use is. So let's go on to this next paragraph. Hopefully you guys can see. So we have determining fair use. To get a general sense of how fair use is applied, one must understand a set of fair use factors outlined in the lineage of case law dealing with copyright infringement. Like I said, case law. These factors are weighed in each case to determine whether a use qualifies as a fair use, often through varying court decisions with an expansive or restrictive meaning that could be open to interpretation. If a use is deemed not to be fair use, then one would essentially be infringing on the rights of the copyright owner and may be liable for damages. Unfortunately, even if you strictly follow these factors and the copyright owner disagrees with your fair use interpretation, your dispute may have to be resolved through litigation or payment of licensing fees. The last sentence, it goes exactly to what I was talking about before. Anyone can sue anyone for anything, even if it's a frivolous lawsuit, even if at the end the fact finder, such as a jury or the judge, finds that there is no that it is okay for the defendant to be using the copyright works. You still have anyone can sue anyone for anything, and you will have to pay lawyers in order to defend you in a court of law, which can be very expensive, and even more expensive if it goes to trial. So with that being said, let me just continue on. Fair use in the general sense, with no hard and fast rules, is the use of copyrighted material without permission from the appropriate copyright owner for a limited and, as the courts deem, transformative purpose, so as to comment on, criticize, or parody such copyrighted work. Specifically, the Supreme Court emphasized that the transformative nature of the use determines whether the material has been used to assist in the creation of something new, rather than merely copy verbatim into another work. In other words, one must ask, has the material taken from the original work been transformed by adding new expression or meaning? And two, was value added to the original, thereby creating new information or new aesthetics or new insights and understandings? So generally, two categories are used when making a fair use. Number one is commentary. Number two is parody. Typically, when focusing on news and editorial reviews, one should look at the first category, commentary. So basically, such as like what I said before, educational YouTube channels, and the ABC News, or like the major news outlet. When commentating on or critiquing a copyrighted work, fair use principles would allow one to reproduce some of the works to accomplish one's intent. Like I said, is trying to curb the second effect of copyright lawsuits, which would be in which it would limit creativity, but then it would negate some of the limitation on creativity by allowing others to borrow copyrightable works from one corporation, one person, in order to further create more beautiful pieces of work that contributes to society. Okay, so let me continue on. Courts have generally used 4 factors in resolving fair use disputes, which are laid out in Section 107 of the Copyright Act. Good old Section 107. Number 1, the purpose and character of the use. Number 2, the nature of the copyrighted work. Number 3, the amount and substantiality of the portion taken. And 4, the effect of the use on the potential market. Man, these are a lot of elements. But let's go through them one by one and then apply them to Project Melee. And this is, like I said, this is my own opinion about how the legal landscape looks in relation to the Project Melee community. So element number one, we have the purpose of the use. So let's read this together. The purpose and character factor is the determining factor in many fair use decisions, as it allows a court to take a subjective, as opposed to objective, look into the potentially infringing party's intention behind the use, particularly in cases involving news reports, footage, reviews, and sports highlights. This factor typically favors the party claiming fair use for various reasons. The first thing we need to know is that copyright protection does not protect factual information conveyed in the copyrighted work, meaning that publicizing the scores of a sporting event or other factual information such as injuries, retirement, and so forth is considered fair use and does not constitute copyright infringement. What helps to strengthen a fair use argument in a case not involving the use of mere factual information is the use of the copyrighted material for the purpose of legitimate news commentary. Now, is Super Smash Bros. Melee or Super Smash Bros. Brawl composed of factual information such that shows something like how many points the Broncos won against the Raiders in 1956? No, it does not. I'm not saying that that is. I'm not really talking about the overall element as compared under the scope of Project Melee, but I'm just saying that this does not fall under educational or news report exception that would. But then keep in mind that those two are just strong examples that would help the defendant in the first element for the purpose and character of the use, aka for example Project Melee. Now let us. I'm going to continue on with the paragraph. For example, when using a clip or photograph to report the results of a sporting event or other factual information, courts have regarded the use of copyrighted material as fair use when the use is, number 1, brief quotations only, number 2, presented in a news report, and number 3, presented in a newsreel or broadcast of a work located in the scene of an event being reported. Like I said before, it does not apply. It should not apply in this for Project Melee or in the overall scheme, totality of scheme of Project Melee. But the analysis doesn't really end there. So let's talk about the purpose and character of the use. So, what is the purpose of Project Melee? Well, Project Melee was basically a result of basically a journey of developers who love the competitive aspect of Super Smash Bros. Melee, and they were basically assumedly upset at how the brawl's gaming or the gameplay mechanic turned out to be. Basically, it was not similar to what Melee's engine was, and of course they thought that Melee's engine was physics engine was far superior to Brawl in terms of the of how it would foster the competitive scene, because they're used to a gaming engine that was more fast paced and had more techniques, even though if they might be exploitation of the physics engine, such as wave dashing and L canceling, and so on. Basically, it was a love project, in which they created a project by taking the again, I'm assuming this copying and pasting the entire Brawl code and replacing the physics engine with an engine that most closely resembles Melee's physics engine. I do not think it was possible for them to copy and paste Melee's physics codes into Brawl because they are different products. Please correct me if I'm wrong, but they actually. But I'm guessing that. But I'm thinking that they created their own codes in order to substitute Brawl's physics engine. So that's basically the purpose of Project Melee. Now, as you saw in this paragraph, in this highlighted paragraph, it has to be looked at from a subjective standpoint. Now, a lawyer can craft a great or horrible argument appealing to the emotions of the jury or the judge. A horrible example would be something like this. It was Project Melee was created just to satisfy the egos of the Project Melee developers. now that's a terrible subjective argument to make, right? Well, as opposed to a good subjective argument, argument based on subjectivity that would be presented in front of the judge or jury by saying that this was a love project by a group of Melee Super Smash Brothers enthusiasts who thought that Brawl was missing an essential element for it to be competitive in the competitive scene, which would be the same, which is why they created their own codes, endless hours of codes in order to substitute that with Brawl's physics, in order to create a new scene in which the new Smash players can eventually get more interested into Melee after being exposed to Project Melee. Now that would be a decent argument, at least a decent argument to make in order to appeal to the emotions of the jury, or judge. And of course, let's get into the character of the use. Well, the character is that the entire code was copied from Super Smash Bros. Brawl, and only the physics engine portion was substituted by Project Melee developers' own codes. Stuck in there. That does not look good for the defendant. But then the purpose of it can be it does benefit. It would benefit the defendant in that in a subjective kind of way, which is of course allowed under case law. So let's go on to the second factor. So we have the nature of the copyrighted work, published or unpublished. The scope of a fair use is narrower for unpublished work because an author has a right to control the first public appearance of his or her expression. Therefore, you have a stronger argument in favor of fair use, basically in favor of the defendant, if the material copied is from a published work rather than an unpublished work. Of course, Melee and Brawl, Super Smash Bros. Melee and Super Smash Bros. Brawl were both published works. but then I guess it would, in my opinion, it would benefit the defendant by a little bit, very little bit, not as much as the first element, the element of the purpose and character of the use. All right, I'm going to need some water, guys, before I go on to the third and fourth element. So I'll be right back. Sorry for the delay, but what's it called? But I really need to recover my voice. Thank you very much guys for understanding in advance. Be right back. All right, I'm back and I am rejuvenated. Okay, so let's go back to this. So, like as I said before, 4 elements. So we had purpose and character of the use, nature of the copyright work, published or unpublished, amount and substantiality of the portion taken, and effect of the use on the potential market. I am on element number 3 for the fair defense use. As I said before, fair defense use is an affirmative defense to that, even if Nintendo or even if a company like Nintendo or such as Nintendo or Sega or anything like that, or any other companies like that, brings a lawsuit and proves that there was a that is copyright that the defendant infringed upon their copyrighted products such as Super Smash Bros. Melee and Super Smash Bros. Brawl, that affirmative defense can still negate all their pretty much negate all of their findings and would mean that the defendant wins the lawsuit. For lack of a more elementary description, I should say. All right, so here comes the hard hitter. This element does not look. Sorry, my cat's Puka is crying right now. I'm going to go close the door, everyone. So be right back. I'm very sorry about this. I guess she doesn't want to hear about Project Melee. Yeah, I guess my cat Puka does not want to hear about this element because it's just too sad to hear. Oh, jeez. Let's see. All right, so let's go ahead and read the third element. So we have amount and substantiality of the portion taken. Yeah, it does. This title makes me nod my head. A general misunderstanding of fair use application has led to the 7-second rule, which many clear representatives follow. A brief use of footage may not be deemed fair use unless all fair use factors can be applied. But the amount of footage used is a key factor in determining if a use is not fair. Sorry about that. As highlighted in the key 1977 court case. I think it's a CBS case if I remember correctly. It was about a news it was about a news source being sued about for like a old film or something like that. So we have this. Okay, so I'm going to continue reading on. The Second Circuit found that a CBS affiliate's use of a 1 minute and 15-second clip of a 72-minute Charlie Chaplin film was not a fair use when used in a news report about Chaplin's death. The court deemed that the portions taken were substantial and part of the heart of the film. The court's analysis may have been different if CBS had used only a limited portion of the footage to simply enhance its news commentary on Chaplin's death. The second court's ruling is a clear indication that this type of use will never be considered fair use. All right, well, amount and substantiality of the portion taken. Let's talk about that for Project Melee. So you have a Project Melee, which assumedly copied the entire code from Super Smash Bros. Brawl and possibly some code from Melee just to understand how it works, and basically substituted the physics engine portion of Brawl with their own coding. But that's only one part. But the physics engine is only one small part of the entire game itself. As I explained before, you have the characters that are copyrightable, each and every character, including Sonic and Snake, which are from third-party corporations, meaning that the third-party corporations such as Sega and Konami can also sue independently in a totally different lawsuit against anyone involved in the Project Melee. Then we have the stages. Each and every stage is unique. It's a copyrightable work. That's like 50 how many, like 30 to 40 stages, maybe 50. I didn't really count. And then you have music. You have the music from different you have music that's not only from Nintendo but also from other corporations, Sega, Konami. I'm pretty sure some other ones which Nintendo put as per permission or licensing, or they paid the third-party corporation for licensing for the music. And then you have let's see, you have the menu, which has its own style. You have the single player game modes. Each one of them is copyrightable. You have the story of Super Smash Bros. Brawl, which is copyrightable. I'm pretty sure in Project Melee you can play through Project Melee using the Melee with the Melee physics. That is copyrightable infringement. Copyright infringement. You have, let's see, man. You have the introduction. You have the introduction movie, which is copyrightable. Let's see. Does Project Melee have? Oh yeah, and also the posters for Project Melee. I'm pretty sure they advertise Project Melee, not with money of course, but just through different websites. They have Nintendo characters in there. They have a Sega character in there. Sonic. They have a character from Metal Gear Solid. And even the name itself is oh, and guess what? There's also a trademark. I totally forgot, but I should have mentioned this earlier, but there's also a trademark aspect of it in which they're using the name they're using a Project Melee, which is a clear derivation from the name Super Smash Bros. Melee. And that's also another lawsuit that they can bring other than copyright. But and it might even play a bit of a part in the copyright analysis, because sometimes different intellectual property laws can go hand in hand. It's not uncommon for there to be multiple different intellectual property lawsuits against a single entity or person for copyright infringement, trademark, and even patent. And I don't even know what parts Nintendo patented for maybe and possibly even the codes, possibly even the physics code were patented. Who knows? I don't have access to that information. So yeah, sorry about the bad news, but concerning those other intellectual properties, not good. Anyways, so going back to the amount of substantiality of the portion taken, it looks horrible in my opinion for the defense, and it will probably even override the first two factors that we even saw earlier. So that really works against using the fair use defense as an affirmative defense. All right, so with that being said, I'll go on to the fourth and final element. So we have the effect of the use on the potential market. One of the most important fair use factors is whether the use deprives the copyright owner of income or undermines a new or potential market, Smash 4, for the copyrighted work, Smash 5. If a copyright owner feels that he or she has been deprived of income, this is likely to trigger a lawsuit. This is true even if you are not competing directly with the original work. Here, yet another factor that does not look too good for our Project Melee community people. Of course, they're not competing directly in the market against Nintendo. They're not selling Project Melee. But there's also analysis of whether it can indirectly affect the income of Nintendo. Because let's just put it this way. Oh no. Puka just opened the door forcefully. Anyways, it does not matter. It does not matter whatsoever if you increase Nintendo's income because you're introducing people to Melee. It doesn't matter legally in the legal analysis, and especially in the light that Nintendo is not creating more Melee copies in the market. Rather, people will buy it from the secondhand stores or from Amazon for or eBay for used price. Nintendo is not getting anything from the used game market. So that would not help. Most likely. That's just my opinion. And the problem is that a company like Nintendo can show that there's a deprivation of income. There could be potentially deprivation of income from the act of having people who were interested in the Super Smash Bros. Brawl play Project Melee instead of purchasing Smash 4 or Smash 5 in the future. Who knows? So there's also that argument that can be put forth. And as I said earlier, this last sentence holds true. This is true, quote unquote, this is true even if you're not competing directly with the original work. So, and the thing is that there is some financial gain from Project Melee, not directly, but indirectly. And doesn't matter if it's to the developers or to the community as a whole, because you are giving the because of tournament organizers are setting up tournaments, and they're charging venue fee, they're charging entry fee, and the entry part of the fees goes to their own pocket, and the other parts of the fee of the tournament pot, the entry fee, goes into the professional Project Melee players' pockets. Now that's still creating a whole new market, and of course it will not be competing directly with Nintendo because Nintendo does not have a competitive scene. But then, as I mentioned earlier in this last sentence, this is true even if you're not competing directly with the original work. It can still be found that it does have a effect on the use of the potential market, and a company like Nintendo could even argue that it's affecting their ARMS competitive scene, because people could be possibly playing ARMS competitively and purchasing ARMS instead of playing Project Melee, and moving on from Brawl and playing Project Melee instead of playing ARMS, for example, or even Splatoon. Well, ARMS is a little bit more relevant because it's more of a fighting game, much like a Smash game is. So I'm just going to read this last paragraph to sum up. Does fair use apply? So, although the four-factor test of Copyright Act Section 107 provides a firm foundation for understanding which uses are fair uses, courts have famously favored different factors in different cases, resulting in very unpredictable outcomes. There is a sizable gray area in which fair use may or may not apply. So, as I said before, I did not do any extensive analysis on the different case laws in the Supreme Court or in the Appellate Court or Court of Appeals ruling. And the Supreme Court rulings have deference across the United States, while Circuit Court of Appeals only have effect on their particular circuit. A circuit, for example, Ninth Circuit Court of Appeal would be California, Nevada, I think Oregon, Arizona, Washington, and maybe I missed a few other states, but that's for example. We have a different circuits in which a Court of Appeals ruling will only apply for a certain region, so you have that issue depending on where the venue is of the lawsuit, which state or which circuit was the lawsuit was filed in under. And just like the last sentence says, there is for fair use doctrine. There's no fast and steady fast rules as to what constitutes fair use. It can be different. There can be different case laws for different fields, such as video game field, or something with us, or a case containing a weird fact pattern, such as such as in this case where there is a group of dedicated melee enthusiasts who happen to be proficient in computer science and coding, decide to rip off the to rip the codes off the entire game of Super Smash Bros. Brawl and replace the engine code in. So, and that's a very unique situation. So you never know. But then for most of the cases, we have these four different elements that can determine whether the infringing work would be considered fair use or not. And it looks like the direction is pointing against the Project Melee community in the event of a lawsuit. So and this is just my own opinion. And as I said before, this is not legal. Anything that I said does not constitute legal advice whatsoever. I am not your attorney. You are not my client. You shall not use my whatever I said or this video or recording of this video to rely on for making your own business decision that could or potentially have legal ramifications to you or to anyone else. So there you have it. Fair use defense is one of the many defenses, affirmative defenses that can be used. But I think that, in my opinion, I think only fair use doctrine can be would be the most applicable affirmative defense in this situation, in the landscape of Project Melee. So there you have it. That's my own my own opinion of Project Melee in the field of copyright law. And of course, Nintendo, a company such as Nintendo has every right to sue anyone involved in Project Melee or in the community if they want to, because unlike us common folks, Nintendo has the resources, has more than enough resources, financial resources, to sue whoever they want, and also they can choose to send out cease and desist letters if they want, although that would only be more like a warning. And the funny thing is that you don't even need to send out cease and desist letter just to sue anyone. Cease and desist letter, like I said, it's just a heads up, or it's just used as a preparation for a lawsuit to prove more monetary damages to be awarded in the future. So there you have it. All right, so let me just read a bunch of comments. Let's see. I'm suing Plup because he didn't invite me to go golfing with him. Bizzarro Flame, a quote by Bizzarro Flame 2018. It's hilarious. Yeah, let's see. Will Thunder asks, how